like to speak a little more about what happens at a hearing because I find that many of my clients are anxious about it. First of all, if you watch television law shows, put aside any hopes for a glamorous courtroom or an exciting jury. That isn't going to happen. The good news for those who are anxious about it is that you will be in a relatively small room, sitting around an ordinary table. You will have your lawyer with you. You will have the court reporter in the room, and you will probably have a vocational expert and the judge. That's it. No one else will be in the room. You'll be asked questions by the judge, and the judge will give your attorney an opportunity to ask you questions. This is a very important part of the hearing because it's when your attorney establishes all the things you can't do because of your mental or physical impairments. Now, you also will have a chance to offer lay witness testimony, and I encourage my clients to do that, to bring their spouse, their significant other, their parent, their friend, their child, to talk about how they've changed and what they can no longer do. The next step of the hearing is when the judge turns to the vocational expert and says, in light of this person's education and training and past work, can they do their past work now? And if not, could they do some other work? Now, be prepared. Some clients find this stage very upsetting. Why? Because in the land of disability hearings, that vocational expert is required to find any other jobs you can do. And sometimes those jobs are ones you've never heard of and you would never want to do. But that's not the end of the matter. That's when your attorney is very important, because your attorney will cross-examine the vocational expert, hopefully to the point that the vocational expert will say there are no jobs that you can do. And that's what your hearing will be like. Rarely will you find out the decision at your hearing. Usually you will wait approximately 3 months to get the judge's written decision.